Good morning. Good morning. Hello, hello. As we get people filing in here, please share the stream. You are on X. Find us at LawPod Daily. Repost us. If you're on YouTube Live or on Rumble Video, Freedom Lover BTL, good morning. Lutrell, good morning. Should have a fun show today. How is everybody this morning? Can we get a heat check? Heat check. It's Thursday. Tomorrow's, Friday the 13th. Anybody watching any Halloween movies? I know we had Halloween 4 on last night. Kind of wild. See Justin Carta doing the Lord's work, sharing us on X. Thank you, Justin. So it looks like we'll have a pretty fun show today because it's just me. No, I'm kidding. Norm is on West Coast time physically. I think spiritually he's still on Eastern Standard. So he will be reportedly, he'll be calling into the show in about 15, 20 minutes. And we'll try to keep it to a nice, tight half-hour show. Today, I think what's top of mind for me is a lot to do with social media. We've talked a lot on this show about the role of social media in our modern institutions and modern culture. I think it's pretty unavoidable. If you are an entrepreneur or anyway involved in business, certainly something that's unavoidable. It's a necessary evil, as it were. It is the way to connect with the consuming public, whether you offer products or services to sort of in a business to consumer category, even in a business to business category. I think being online, negotiating and navigating, certainly, unless you're doing something like, making wood pallets or something much cooler than indulging the warfare that is the online world. I mean, that's kind of the dream, right? Just to sort of retire out to, manufacturing paper clips or something where you can have a dusty, empty, neglected social media account on whatever platform with some sort of random assortment of numbers and underscores just trailing behind it somewhere. People that come across it, they probably don't even know it's you, kind of thing. Isn't that the dream? I kid, but not really. I think that is sort of Mike being jaded talking. Good morning in the cloud. Good morning, Hans. Good morning. It's me again, Sai. Hello to you all. We're missing the other angry dog this morning, but we have Mari in the chat. You have a dog. That's good enough, right? Nah, don't let Uncle Pat hear me say that. So without taking too much more time here to just BS a little bit, there is the OG angry dog in the house, enjoying a cup of Joe. And someone's telling me that the music is still playing. Is that true? What about now? It's not playing for me. That's the problem. Let me know. Is it still playing? Not playing? Playing? How are we doing? Tell me, Jeff. It says music. Good now. Great. Sorry about that. Still playing around with the it's off. Thank you, TC. So three major stories here this morning. The first I'll go ahead and tease because this is what we're going to have Norm come on and discuss today. And I will put it on the screen for us now. It's this reporting from the New York Sun that Jack Smith is accusing Trump of wielding social media as, quote, weapon, seeks to block him from friending potential jurors. We will most certainly have Norm call in and discuss with us what this ultimately means. As we all know, as sort of a foundation and baseline, uh, any accused in a court of law in a criminal capacity has a right to a fair and impartial jury of his or her peers. And in the context of this story, just sort of setting the backdrop, uh, there are the anecdotes that involve Trump discussing various people within, asking questions via Truth Social about the relationships between certain people and those involved in his prosecution in different respects, whether it's the civil stuff in New York, whether it's the criminal stuff in Georgia, or whether it's the criminal prosecution in D.C. And special counsel Jack Smith is now appealing to the D.C. court, aiming to limit or restrict Trump's legal team from being able to use anything more than the information that may be gleaned from a publicly available social media profile in the cross examination of potential jurors during jury selection. In other words, um, Jack Smith is attempting to preclude Trump's legal team from being able to introduce any sort of evidence or any tendency to show impartiality or a trend toward impartiality on behalf of one or more jurors that are being selected via that process, as we know as voir dire. So this is a big deal. I want to defer to Norm's instincts on this. He is certainly perhaps the best situated person um, uh, in this realm to give an observation and what it means to him. So we'll go there when he calls in another 10 or 12 minutes. But what we can pivot to now is what I'm really interested in talking about, because we've talked about it before, and it is the TikTok v. Montana lawsuit. Now, I believe in previous streams, and those of you who attend regularly and have perfect attendance, you may recall that we've discussed the First Amendment, one's right to freedom of speech, freedom of the press, etc., freedom of association in the context of social media. In fact, that is the dominant narrative as it relates to social media in the modern era, 2023 and beyond. And those of you who are taking good notes have probably realized as of late that I am becoming skeptical that the First Amendment argument is the most effective to curb the true nature of the problem that is social media, right? So with that as the backdrop, I just want to introduce the lawsuit here. This is a lawsuit that was brought by the plaintiff is Samantha Alario, but also TikTok Inc. And they sued the Attorney General of the state of Montana in response to the state of Montana's legislature passing Senate Bill 419, which promises to preclude TikTok from operating within the boundaries of the state, effective January 1st, 2024. Today, the federal court in that case, and I believe that federal court is, I think it's a Montana federal court, and I'll verify that. But that court today is going to hear an argument on TikTok's motion for a preliminary injunction. Essentially, we've talked about the nature of preliminary relief before, but TikTok is arguing to the court that, even though that law is set to take effect on January 1st, that that there is such merit to its claims here that there is an abridgment of its rights and the other plaintiffs' rights, that the court should consider staying the application of that new law until such time as the lawsuit has fully played out, that the suit is that there is a finding on the merits. And that's meaningful. But what they're arguing is that it is an unconstitutional abridgment of the First Amendment. And there is an amicus brief that's also been filed by what is known as the Digital Progress Institute. And so I'm going to put part of that here on the screen for us because I do want to read a little bit from that. And I promise I'll get to my issue with, again, my thesis here is that I think that in the context of social media companies aggregating data, those that are known for sort of violating those Fourth Amendment rights to privacy, I think that there is no real meaningful distinction to be made between those that are considered, adversaries of the United States versus, allegedly domestic companies with respect to the treatment of that data. I actually believe that the true nature of the problem lies somewhere within more of a vices category, very similar to the way that I view the regulation of beverage alcohol and spirits, the way that we view the regulation of tobacco, etc. And it's not obvious to me that by continuing to litigate these issues along the grounds of the First Amendment is going to solve the overwhelming problem that is the top-down coercive behavior of the algorithms that drive the revenue for these companies, right? Asking the question about how our individual behaviors and collectively how those behaviors coalesce and co-align to effectuate certain habits in the marketplace. I believe sincerely that there, when we talked about Vivek Ramaswamy and his affirmation that there should be an age of consent or an age of majority rule with respect to use of social media, I told Norm on stream, I said, that really appeals to me because I have grown through the introduction of social media. And I vividly recall a time when things were still analog. And then it wasn't as though the version of the internet that we take on today is remotely the same or is the same as it was at the time that we were hearing the dial-up tones for AOL internet or any of those things, that when we were using a browser called Netscape or logging into chat rooms and whatever else. The internet landscape has shifted completely. It has been thoroughly cleansed and sanitized. It has been curated in a way that is, a bunch of mainstream highways, and we all sort of exist within the version of the internet made available to us. And therein lies the problem with advocating for speech restrictions thereon, or community notes, or whatever. But this now has become, in my opinion, some sort of ingredient, some sort of agent or chemical or something. Right? There is a biological element to the way that individuals react when presented with certain information in a certain manner and engage with that on certain devices. It does feel very much like a vice. And we've got Norm calling in now. So I'm going to take this call and I'm going to tell him he's interrupting. So bear with me. Norm, can you hear us? Hold on. Let me make sure you're on the roadcaster here. Are you there? Are you there? Are you there?
I am. Yeah.
All right.
Can you hear me?
There it is. All right. So you're live with us, and I was wasting a lot of time trying to get into what I wanted to say about the Montana v. TikTok lawsuit, and you interrupted. So you're rude. But you're more than welcome to take us away, because our audience was starting to agree with me that there needs to be an age of consent around the use of social media. So maybe I don't need to do that before you have a chance to really defend yourself.
Defend myself against what? Here I am in LA minding my own business up at before dawn, and I'm being attacked in absentia. Peeps, help, help. I'm trying to defend myself against the ravages of Mike Foyer. An age of consent for TikTok, an age of consent to get on social media. I don't know. I mean, I understand that social media presents a challenge to the developing brain, and maybe we need to view social media as vaping. But it seems to me that this is one step closer to saying that somehow speech needs to be regulated in public. And I know that you'll say it's not speech, but it's access to a communication that has the potential to be enormously disruptive to a developing young person.
No, I just think it's like a pack of cigarettes or a pack of beer, right? I just think that there just needs to be an acknowledgement that there is an inherent, that there is something that's done to one's cognition and to one's consciousness and inhibitions and but we don't totally understand that, right? When it comes to cigarettes and nicotine, or when it comes to beverage alcohol and the active alcohol in that, we understand in a very realistic sense what those various agents do when introduced into the body. And then, every individual's, own reaction notwithstanding, there is a reason that we put an age restriction on those things. And my point, I think, that I'm rushing to get to now, because I really want to hear you talk about Jack Smith and Trump. What I'm rushing to now is to say that that it's not obvious to me, Norm, that this is a speech issue really at all. I think that it is sort of an ingredient in a drug issue cloaked as a speech and an access issue. And I think that needs to be addressed for what it is, because we know we're watching things happen.
Cigarettes. There are those who view cigarettes properly as nicotine delivery devices, and therefore what you're doing is you're not regulating the desire or the need or the interest or to smoke, but rather you're regulating access of a young person to a nicotine control device, recognizing that nicotine is in and of itself addictive and potentially toxic in one form or another. TikTok, what it's delivering, I suppose, are electromagnetic impulses to a brain. But it really, what it's, and so what you want to say is that the delivery of these electromagnetic impulses in this pulse, or in this form rather, requires regulation, because otherwise there'll be an adverse effect on the recipient. The problem is what you and I are transmitting across the internet right now are electromagnetic impulses. And so this becomes perishingly close to an Orwellian form of controlling when and under what circumstances people can have access to which types of ideas. And so it's almost saying that we need something like Margaret Atwood's Handmaid's Tale for kids. We need to put a cowl on, a collar around them, something that protects their ears and eyes from things that may disturb them. And among the things that may disturb them are the ideas that come with that. And so how do you draw the line between an idea and the technology that delivers it? And if you create a mechanism of control, will it become quickly and easily enough a mechanism of censorship? And might this be consonant or of a piece with those who desire to impose hate speech restrictions, or who want to have bureaus that control disinformation? Because if those electromagnetic impulses and what are carried by them are so disruptive to a child, well, aren't they also for the mentally disturbed, for the weak among us? Or aren't certain ideas so radical and difficult that in an era of quote-unquote climate change, we need to impose restrictions on climate deniers or vaccine deniers, or people who are on one side or the other in the Arab-Israeli conflict? I hear what you're saying about children, and I do think that parents should have the right to control what their children have access to. That's part of rearing and raising a child. I'm just very, very, very reluctant to give.
And you should be, because I don't think that I've fully articulated. I think that I need to get a level above where we're sort of stuck talking in terms of what I'm talking about. Because
I keep circling the same drain, and you're getting it, and I sense your frustration. So we do need to step this up.
And we will. And just to be clear for everybody listening, the TikTok v. Montana lawsuit, again, is about the data harvesting and the and the storage of data and information about American citizens and American users by Chinese companies, right? So the basis for the First Amendment lawsuit that has been brought by TikTok is necessarily to say that the bill in Montana, as ratified and set to go into effect, is an unconstitutional abridgment of TikTok's First Amendment rights and of the individual plaintiffs' First Amendment rights. And TikTok has consolidated all of its individual users' claims here in the U.S. into its lawsuit, and is advocating on its users' behalves as a unit. So what Norm and I are talking about right now is framing that I've kind of drawn us into. And I want to be clear: the lawsuit that I've got on the screen and what we're talking about is not at all to do with sort of that sort of dopamine. That dopamine bandit, that dopamine privateer that is a social media algorithm, and it's not at all to do with what I'm attempting to, I guess, create as a meaningful narrative to discuss. But nonetheless, it does give us the opportunity to have that discussion, or at least to start it. So, Norm, we will get back to that. Let's transition over to the Jack Smith special counsel jury selection article that I sent you this morning from the New York Sun.
So, in the United States, you have a right to a fair and impartial juror if you're accused of a crime. And that doesn't mean a jury or juror who is totally ignorant about you, especially if you're the former president of the United States, but rather a person who can decide to put aside whatever preconceptions they may have and commit that those preconceptions aren't so strong that they will color what the person sees in some meaningful way at trial, and therefore can set aside extraneous influences and decide the case based solely on the evidence they hear in a courtroom. That's the goal. But we all know that people come to court with biases, with opinions. At least we hope they do. If they don't, they're probably disqualified from jury service on the grounds of some sort of mental incompetency. So the question is, what rights do parties have to learn about jurors, and nowhere do jurors express themselves more powerfully. Well, it's probably an overstatement. Jurors express themselves quite powerfully in a social media context. And so it's become the norm in cases for parties to check out people's social media posts. Thus, for example, in the Proud Boys trial, Sabino Haragi in Miami was one of Enrique Tarrio's lawyers. He did a masterful job of taking the names of jurors and running them through social media accounts. And what we learned about many jurors is their associations told us plenty, who they followed, who they liked. It was almost as important as what they said. And so we were able to get this information and use it to propose questions to be put to jurors. And those questions resulted in many disqualifications of jurors. It raised many red flags about jurors that the court ultimately permitted to sit. Now, I don't think Smith is challenging that, though. I think, as I understand it, Smith has filed a motion basically saying he wants to prohibit Trump, in particular, and perhaps Trump's legal team from quote-unquote following social people on social media.
Yeah, and I want to stop right there for a moment, Norm, because the way I introduced this to our listeners is essentially that what Jack Smith desires of this is to limit Trump and Trump's legal team to information that they could glean merely by visiting the profile of any of the potential jurors, the online profile, whether it's a Facebook profile, for example, or an X profile, for example, anything. And just what would be publicly available. In other words, Jack Smith wants to guard anything beneath the surface of what that individual potential juror would reveal to the public, that any member of the public that they are not directly connected to by way of like a friend or a follower or something like that. Is that how it appears to you as well?
Well, I don't know what that means.
So I'll explain. I'll explain. So let's say we each have Facebook profiles, Norm. And let's say that, for example, you have your privacy settings set in a manner such that anyone who is not a friend of yours, if they go to visit your profile, perhaps they see your profile in a people you may know kind of thing, right? And they click on it, but they go to your profile. If they're not your friend, you could have your settings set in a way that the only thing they could see perhaps is your profile photo and your name, but nothing about your profile that you would otherwise share with your network is available for them to consume or to see or to learn. They may not even have the ability to click on your profile photo to enlarge it. It can be that restrictive, right? It could be even more restrictive than that. So what I'm saying is that what Special Counsel Jack Smith is doing is a clever way of asking the judge to make sure that Trump or any member of his legal team cannot go and friend any of these potential people, right? And saying that, in other words, say a member of Trump's legal team, a staff member, an administrator, a paralegal, or something like that, friends certain people who are known to be within the jury pool, right? Potential jury pool. And they're able to see more by friending them. Say that friend request is accepted and they're able to see more. And then by seeing more, they can see that they tend to post in favor of certain political parties and stuff like that. It occurs to me that Jack Smith is trying to preclude that sort of real information that would get at the heart of the nature of what it means to be partial or impartial, by limiting Trump and his legal team's ability to see crystal clear information about that.
Yeah, that's a better way of putting it than the article I read on it this morning does, and it raises more profound issues. So, clearly what we expose to the world at large in our public faces on social media is and ought to be fair game for inquiry. If I say Trump 2024 and then I'm being asked to sit on the jury, it's a reasonable question for a prosecutor to ask whether, having said that, my Trump 2024 inclination will lead me to be biased in favor of him and against the government. That's reasonable. If, on the other hand, in my private thing, I'm talking about my disdain for Jack Smith or Joe Biden or the Justice Department, should the Justice Department be able to know what I don't hold out to the world in public? Should they be able to have that level of inquiry? The courts take extraordinary steps to protect the privacy of jurors because jurors have sacrificed a lot to sit on a jury. It's obviously a privilege and an honor and an important part of the American political process. I think the court is likely to strike a balance in protecting juror privacy and say that the line that distinguishes what parties can do in their research on jurors will tilt in favor of prohibiting contact with jurors in the course of the proceedings that interferes with their privacy. What does that mean? The parties will be given a list of jurors. They'll be given a list of their names. The names will be kept from the public, and the jurors will probably be known as, juror 1, 2, 3, 4, 5, 6, and 7. But the parties will have a list of those names before jury selection. It may not be much before jury selection, but before jury selection. And then private investigators and whatnot and lawyers will scour through their social media accounts looking for information. It seems to me that prior to the proceedings beginning, if a party wants to do a friend request so that they can get access to private communications, that seems to me permissible, and it should be permitted because the person has engaged in a platform that gives the world at large an opportunity to request to become their friend. If a person makes a request, then they let that person into their private lives, at least to the degree that the friend restrictions apply. What the line to police, though, is at what point does this become more than a merely passive enterprise of learning, and at what point does it become an attempt to manipulate a juror? So I'm an investigator for Donald Trump. I'm in Boyer's friend thing. I see Boyer's got lightning rod issues or attitudes about one thing or another. Do I ask questions? Do I attempt to influence him? Or do the questions I ask of him attempt to influence him? Or am I directing him to like other pages? Or am I sharing his information in fora that might bring others to, that might inspire others to try to influence the juror? That line about jury, because that line policing inquiry from influence is a subtle one in social media. And so I think that Smith is apropos Trump's publication of the New York judge clerk's photo with Schumer in comments. I think that's what Smith is worried about. That somehow the team will publicize this information or use this information to the embarrassment of a juror. I'm not sure I'm worried about that. And I thought in the New York judge clerk case, that was a ridiculous concern on the court's part. I mean, this is what she's exposed to the world at large. Eat it. I mean, that's the way it goes. This isn't a juror. This is a court staff. But as to jurors, courts are solicitous. And so I think that what Chutkan will say is that the public face is fair game, that friend requests after a certain point, perhaps after the point of disclosure of the names, are prohibited as juror contact. And I think it'll nonetheless go on. It'll be outsourced to third parties who will then, whether intentionally or not, people who support the president will nonetheless be involved in this, and they will forward the information to the legal team, and the legal team's still going to have it. And so one thing jurors are told in trial is to stay off social media as it relates to the case. They aren't to read or consume or communicate about the case in general. And if they do, that's a violation of the court's order, and it could result in consequences. And so I suspect in an organization with the resources of Trump's and the support that he has around the country, these jurors will be in a fishbowl. Their identity will be protected. No one outside the legal team is supposed to know who they are. And yet people will determine who these jurors are. There'll be suspicions that the Trump legal team leaks it, and maybe they will. And maybe they'll do it in ways that are private and can't be discerned. The wise course would be for the jurors to stay off social media altogether. And I begin to wonder whether we want to have social media sequestration during trial. You know, it used to be the case that in some cases there was so much publicity, jurors were stuck in a hotel room and refused to use the phone and whatnot, except for limited contact with their family to assure a fair and impartial juror. Now we invite the world into our homes 24/7 with our electronic devices. Do we need digital sequestration during trial to avoid these problems? Because up until the time of trial, it seems to be broad inquiry is permissible. How you police the line between inquiry and influence, that's a tough call here. So well, and cutting edge issue.
Well, and these privacy settings that we're sort of, I guess, impliedly getting at through this conversation, Norm, are not static, right? An individual user can change the amount of information it filters through to the general public at a whim, right? Within the sole and complete discretion of the individual user. That user can go into the settings and change its privacy settings, change its filters, change what information the public is able to see. And so we've got several questions here, and this is kind of why I'm getting at it. T-Girl says 0 chance jurors stay off the socials. I agree with that. But what I think what I'm concerned with is namely this trial is in DC, right? And we're not talking about someone that was not the president from 2016 to 2020. We're not talking about a president that was immune to the protests and the riots and the destruction in DC, in some cases quite close to the White House, the burning of churches, destruction, that sort of thing. And it's, Norm, I'm just thinking of the check-in feature that Facebook offers, for example. What are the odds that one of these potential jurors checked in at any one or more of these riots that had as much to do with the Trump administration as it did anything else related to perhaps George Floyd or otherwise? And when these check-ins occur, right, whether it's a literal geotag check-in or if it's a selfie or a post saying I'm here on this day and time doing this or whatever, right? But then somehow that is pulled back and veiled from view purposefully, right? That's not something that has anything to do with telling a juror to stay off of socials during the course of or the trial, but it is something that may have been reasonably discoverable by the Trump team prior to the jury selection, but for reasons that are, for reasons none other than a user's desire to preclude any sort of public knowledge of that, it's no longer reasonably discoverable based on what Jack Smith is trying to do here.
No, and the problem, of course, is the government has the superior snooping power and superior manpower. I mean, in the Proud Boys case, we were surprised at how little the prosecutorial team acknowledged doing any research of social media on potential jurors. They, you know, if you look at the public record, we were raising questions they hadn't considered, and I sat there the entire time wondering if they just weren't showing their hand. It's hard for me to believe that, given the team of excellent lawyers they put on the case, and the 6 FBI agents assigned to the case as case officers, and the number of other associated federal agents involved in preparing the case, that they weren't doing exactly what we were, just weren't being honest about it. So, you know, I think it's an interesting issue. I don't know what Chetkin will do. I know that she'll tip the scale in favor of juror privacy. The question is, will she and admonish the Trump team not to engage in tampering? And there is a way to navigate these shoals, which makes you an information gatherer rather than a tamperer. And so I think this case is gonna represent sort of a frontier exploration rather, of how far you can press these limits without getting in trouble with the judge.
And you're sure that you don't like my idea of limiting the use of social media to those who are like 16 and older or something like that, Norm?
Yes, I
am. Justin says it's impossible to have an unbiased jury pool in this day and age, a contribution to the decline of our justice system. That's sort of what I'm getting back to, is just ultimately all of this is, you know, we are way in the weeds, to take a line from Jackson Barrett this morning. We are way in the weeds with social media. And I think it's almost unavoidable. You know, the three things that we were set to talk about this morning, we've only gotten to 2 of them. They all have at the heart of them social media as the mechanism by which certain things are being done, right? So in the case of TikTok and data collection and or algorithm production and application on the masses, with respect to the immigration crisis at our southern border and the hot conflict between Israel and Hamas, and the likelihood that the hot conflict moves into major American cities, you know, beginning tomorrow. And then we've got this age of, then we've got the jury selection issue within Trump, right? I mean, all of these things have at their core this issue of the public's use of social media writ large. And none of us have been, you know, really asking the question of to what end do these algorithms get us to make some of these decisions almost subconsciously, right? Are the contrarians and free thinkers among us on the decline without us even realizing, because these algorithms are so pervasive and so powerful that they essentially mete out the consciousness of the individual, right? Over time, we don't know.
Or the alternative is even contrarianism, a trope, a pre-stage trope. Are we who pretend to be free thinkers merely just reacting in predictable ways that make us harmless from the algorithm's perspective? Is the only way to be a free thinker really to detach from thinking it, and to say, you know, here are the trees, here's the grass, here is the cow I need to feed, and that is my world. And of course, that diminishes us all, because the ability to communicate enriches our lives, and sharing ideas enriches our lives. So they're imponderable. I mean, they're ponderable questions. Here we are pondering. The answers are difficult, and I think the Trump case illustrates that. It'll be fascinating to see how it unfolds.
Absolutely. Well, Norm, thank you for being up early. I had a hard out at 8:30, and here I am. It's 8:39, so I really need to run here. But again, thank you for making time on the East Coast. Tomorrow, it looks like we're going to have one Mark Randazza join the stream, so that'll be fun. He and I will probably talk a lot about the First Amendment and the Montana stuff, just to get a fresh perspective from a First Amendment litigator on what he sees, you know, what legitimate arguments are being made by TikTok, and then perhaps what he thinks are a little bit of BS. So anyway, we'll be back tomorrow. Norm, have fun on the West Coast. Tell all those celebs I said hello, and we look forward to seeing you back on Monday.
Ciao. Bye.
Bye. All right, everybody. That is it. I've got to run. I've got stuff to do. Thank you for being here. Obviously, every day. You know how to find us. YouTube, Rumble, X, @LawPodDaily. Yeah. Punch that thumbs up button. Every like counts. And you can also find us on Apple Podcast, Spotify, Google Play, Overcast, Audible, all those podcast platforms. Whenever Mike has a chance to get around to publishing those episodes in audio only, which I did yesterday's earlier this morning. So you're going to get 2 in your feed today. Sorry about it. Anyway, see you guys tomorrow. We'll be here at 8 a.m. Thank you.